All right, guys. So it's 1:05. So I think what I can do is I'll start discussing um, the purpose of our meeting today, which was this to discuss wills and estates. And so I know the times are it's very difficult. I know that everyone is going through a lot of worries and anxiety, if I can use that word. And especially specifically in our office, we've had an uptick of clients who have raised questions, have called us, have asked us about having their wills completed and having their estate planning done. And it's natural, right? I mean, with respect to what's going on, and there's a lot of fear, a lot of uncertainty, and a lot of unknowns. And whenever that does happen, uh, the fear inside of us kind of pushes us towards planning. Um, and it also pushes us towards thinking about our mortality, as sad as it sounds. As difficult as it sounds, we start to think about the what if. What if something untoward were to happen? What if my health was affected? What if my family's health was affected? And I'm not immune to that either. Uh, you know. So what I wanted to discuss with you today are basically some of the things that we should be thinking about when we prepare our wills. And if you want, what I will do is I'll provide my email address to everyone, and you can email me, and I can also provide you a checklist of if you've missed anything. If it's hard to follow along. It's very verbal right now. You may miss something. You may have a question to ask. So what I may do is I'll actually send out a memorandum of the things that we discussed today, just so that you can, keep a checklist and make sure that that you haven't missed anything. I understand that the video is being recorded. You can always go back to it and refer to it, but sometimes having things in writing is just easier for people. I know that, for me personally, going back to something that I could read is easy. So the first thing I want to discuss with you is whenever you're planning to do your will, what you want to think about first off is who do you want to have as your executor? Now, that is the colloquial term that we use for um, for someone who's going to be handling your estate after you pass away. Really and honestly, the legal terminology would be it's your estate trustee with a will. And your estate trustee with a will is the person who is going to be handling your estate when you pass away. And most of the time, people use the ones who are most intimately known to them, who are most closest to them. If you're married, it would be your spouse most of the time because they're the person who would know your finances, etc. But what you would want to also think about is the know-how of the individual, the age of the individual, right? And you also want to be looking at how much you trust the individual, because these are the individuals who are going to be tasked with the most difficult decisions once you pass away. And what kind of decisions are we speaking of? What we're speaking of is first your estate trustee, your executor, is going to be tasked with paying your funeral expenses, paying your debts, handling your funeral. Those are the immediate things. But there's a lot of work to be done after the fact as well. After the fact is when the nitty-gritty begins. Is when the real difficult task begins, and that would be contacting your bank to advise that you've passed away, obtaining a death certificate, providing a death certificate to the bank. What you would also be doing is that you would be converting certain assets that you own in your own name into a estate account. You'd be filing your intern taxes, your income taxes. You would be compiling a list of all of your assets and all of the values of those assets, because though the individual who's tasked as your estate trustee will also be the person who's going to be meeting with a lawyer to file documents with the courts to have you appointed as a court-appointed estate trustee. So the person named in the will isn't necessarily always going to be your estate trustee. The reason being is that the person named in the will has to apply to the court to have the will approved and to have that person's role as estate trustee to be approved as well. It's when you get that stamp from the court confirming that the will has been approved and that that person's called a certificate of appointment, that's when that person actually becomes the legal estate trustee of the estate. Now, I'll backtrack a little bit because I want to actually set aside an untruth that's out there. A lot of people have the feeling, and it's probably they've got it from the media or they've got it from a TV show or anecdotally from a friend, that basically says that if you die without a will, then the government takes everything. And that's absolutely not true. Actually, that's further from the truth. The only way the government will be taking away your assets is if you have absolutely no next of kin whatsoever. So if you're basically alone, right? You have no children, no spouse, no brothers, no sisters, no nieces, no nephews, nobody. What would happen if you were to die without a will is that your estate would be divided according to what's called the Succession Law Reform Act. That's the statute that deals with people who die in estates. And what it basically says is that there's a percentage by which your estate would be divided. If you're married and you don't have a will and you have assets in your own name, your spouse would be entitled to the first $200,000 of the value of your estate. After that, it would be divided according to your spouse and children, if you have any children, or other family members, according to percentages. So that's just to set aside an untruth out there. So let's go back to who you should be thinking about for naming an estate trustee. So, most people will choose their spouse because the spouse is the person who you most likely will have joint assets with, your house, joint accounts, joint investments. And a word on that as well, that if you have any joint assets, what's called the legal right of survivorship, ownership of that asset, transfers over to the person with whom you have that account joint with. So in the case of husband and wife, it goes to your spouse. With regards to children and parents, I do know some parents have their children on as joint owners of accounts and property as well. Especially if you're in advanced age, it's easier. It's an estate planning tool that you can have. The right of ownership will go directly to it. Some people have investments, mutual funds, RRSPs, GICs, where a beneficiary is named on that investment. That person would be given the value of that asset according to the percentages that you've named directly. So the will doesn't deal with that either. Really and honestly, the will deals with assets that you have in your own name alone. That's it. No designated beneficiary for investments. No joint owners on an asset, such as a house or a joint account. It's only assets that you own in your own name. That's what the will deal with. So it's a long preamble. It's a long discussion with regards to, who and why you should have an executor. What we also advise people is that if you do not, if you're, you should always have a substitute estate trustee / executor, because in the event that estate trustee is either unwilling or unable to act as an estate trustee, then you have a substitute. And most people choose their children. If they do have children, some people choose their closest friends because they can trust that friend. Others use brothers and sisters. Really and honestly, again, it goes back to the same concept. You should be having or naming an estate trustee / executor who you A, trust, and who B, you can feel confident that that person would be able to carry out the duties of an estate trustee without any issues. And obviously, lawyers and accountants and other family members are individuals who can assist, you can lean on for assistance in that regard. So that's, and that's basically, if you were to read through a will, you would see that that's basically the preamble. One, you would, be nullifying any previous will that was made, and then B, you would be naming your executors and substitute executors. The second part, if you were to ever read through a will, would basically say, this is what the rights of an estate trustee or an executor are, right? And it goes through the same thing I mentioned: to call in your estate, to convert assets to an estate account, to pay any debts, to pay your funeral expenses. And then you're basically going to be discussing how you want to divide your estate. And this is where a lot of the discussion happens. A lot of the hard decisions that have to be made, sometimes it's hard, sometimes it's easy, with regards to how you want to divide your estate. Now, for our community, the Muslim community, there are many different variables that occur. Some people have their own ideas with regards to how they want to divide their estate. And that could be, everything to my spouse, if you have a spouse, or everything to my closest relatives. And then should that relative die before me, then, everything to my kids divided equally, or everything to a next closest relative divided equally, etc. Other members of our community are very strict with regards to dividing their estate according to Islamic law and Sharia, and that also leads to other discussions that have to happen. Software is readily available. Resources are readily available with regards to how percentages are divided according to Islamic law. If you were to go and Google, division of estate, Islamic law, or Islamic law, inheritance, or Sharia inheritance, you can find calculators that basically say, okay, well, who's alive of this list, and you click off, and then it gives you the percentages. My one caveat to that is that the law of Sharia inheritance is not tested in Ontario yet. And what that basically means, when I say that, I basically mean that there has been no cases decided in Ontario challenging an Islamic will, and that's a benefit and it's a detriment. It's a benefit because, one, it shows that for those who have died and have an Islamic will, no one's challenged it. However, it's a detriment in the sense that there are no precedents on it. And so if and when an Islamic will is challenged, we don't know what or if, how the courts will respond. The laws in Ontario, the courts in Ontario have typically upheld religious requirements with regards to dowry, for example. If I can give a tangent, dowry has been upheld in Ontario courts, where a domestic contract or an understanding, even if it's verbal and it's witnessed by several people or individuals, if there's an understanding that there's going to be a wedding gift, and even if that wedding gift is, a large amount, the courts have respected that contract as a verbal contract. So, chances are, if your will is sufficiently clear with regards to how you want to divide your estate, and me personally, the way I do it when I advise clients of drafting a will according to Islamic Sharia law, is to not put the percentages in the will, because the percentages are a moving target. And what I mean by that is that what people who are alive today may not necessarily be alive when you pass away. And so the percentages will change eventually. And then what would happen is that you're typically in a situation where, as and when people pass away, your beneficiaries pass away according to percentages, you have to redo your will to change the percentages. And so I typically tell my clients to say that if you are going to have a will that is divided, the estate is divided according to Islamic Sharia law, to explicitly mention that in the will, to say that I, I direct my estate trustee to divide my estate according to Islamic Sharia law. And then what the laws in Ontario have recognized is that you can attach a memorandum to a will. And the three things that have to be apparent with a memorandum is that the memorandum has to be in existence at the time of the will. Fine, you just attached it as a memorandum. B, the memorandum has to be in existence at the time that you die and the will is being ready sent for probate. Okay, fine, you just have the memorandum there, attached to the will. And three, it has to be sufficiently clear with regards to what is being said in that memorandum. And so if, the percentages are set out in the memorandum itself sufficiently clear, then the court should have no issue with regards to satisfying the wishes of dividing the estate according to the percentages set out in Sharia law. And remember, again, it's not the courts that's going to be dividing the estate, it's the estate trustee. So the court basically approves the will, it's the estate trustee that has to follow the directions of a will. And so think of a will as a constitution almost, right? So the will is the law, it's what is the individual's wishes and desires, and it's up to the executor to fulfill those wishes, right? So to basically follow the Constitution, right? So that's with regards to division of estates. Again, some people would like to lay out in great detail how they want their estate divided. So for example, account A to this person, or the value of account A divided according to this many percentages, or my jewelry to this person, charitable bequests to this organization. A note on charitable bequests, that a will should typically state that in the event the charitable organization is no longer in existence on the date of your death, and that is very possible, that your estate trustee has the right or ability to use an alternate charity within the same vein, within the same purpose, within the same thought, or within the same purpose, right? For the charitable bequest. So now, a lot of people have asked and will ask, and in our community, and this is now in the community of individuals with disabilities and children with disabilities and family members with disabilities, how do I divide my estate, or how do I give bequests to an individual with a disability? And this is where, the infamous Henson Trust comes into play. Now, the Henson Trust, it got its name from an actual person. So there's a case in Ontario that was decided at the Ontario Court of Appeal. The deceased's last name was Henson, the beneficiary's last name was Henson. And the reason why it came up is because this girl, she had a disability, and she obtained from an estate. And with regards to how much she received, it disqualified her from ODSP. And so the question is that, well, how do we allow a person with a disability to obtain from an estate, to receive a bequest, a testamentary bequest, without disqualifying that person from ODSP? And I don't know how much everyone knows with regards to ODSP. There's a lot of literature out there. And remember, ODSP does not apply to, or the valuation for ODSP does not apply for your residential home and your vehicle, right? So, I mean, as an aside, if you were to bequest, interest in your home, in the person with a disability's home, that wouldn't disqualify the person from ODSP. If you want to give a car, if that person with a disability can drive, that doesn't disqualify the person from ODSP, right? So for our purposes, the Henson Trust, basically what the court decided is that in order to not disqualify a person with a disability from obtaining from an estate what the testator or the person who has died, I'm going to use legal terminology, but testator basically means a person who has died who has made a will. What that person can do is make an absolutely discretionary trust, and it's absolutely discretionary in the hands of the trustee. Very complicated terminology. All it basically means is that you have to create a trust and you have to name someone as the person who handles the trust. And you have to name an individual who, with a disability, who will obtain from the trust. Okay? So basically, what you would have to think about, and my clients, I've advised them is that, who do you want to name as the Henson Trust? Because this person is going to have, remember, the absolute discretion with regards to handling your relative with a disability's estate or whatever they're obtaining from your estate. And sometimes it's very large amounts. I do know that there are certain clients who have, purchased homes in the 1990s and, early 2000s, and the values of those homes have, shot up exponentially. Sometimes the mortgages are paid off. Sometimes, the value of that mortgage, vis-a-vis the value of the house is quite low, and so there's a lot of equity in the house, and so therefore, the person with a disability under the trust could potentially be receiving a lot in the trust, right? And remember, keep in mind that Henson Trust, the trustee, also has the absolute discretion as to how those funds in the trust are handled. And so, the Henson trustee can invest that amount or whatever amount in the trust, to maximize the value of that estate, right? So, I mean, they can put it in mutual funds, and we've seen what's happened with mutual funds lately. They fluctuate, right? Over time they go up, but not always, as we see now. They can put them in different investments. They can invest in real estate. There's different things that they can do because it's an absolute discretionary trust. The person can basically do whatever they can do to maximize the value of that estate. And so going back to my previous point now, who do you name as the Henson trustee? So a Henson Trust is, typically this is a situation where the last of the two parents have died, because remember, typically what people will do who are married, who have a child with a disability, would be that they would give everything to the one parent upon death, and then it's really when the last parent dies. That's when the child with a disability would obtain from the estate. Long-winded, but it's worthwhile to think about. It's I've had some clients say, well, I would like my other child, if they do have 2 children or 3 children or multiple children, and one has a disability, they would say, I want my other child to be the Henson trustee, which is perfectly fine. But keep in mind that the role of the Henson trustee is great in the sense that there's a lot of responsibility with regards to A, the value of that trust, and B, with regards to how to handle that amount, how to disperse from that amount. The will also says in the Henson Trust that if there are multiple beneficiaries, that they don't have to have an even hand with regards to how they're going to handle the different beneficiaries and the one beneficiary with a disability. So, it also depends on the age of your child, the know-how of your child. Remember, a lot of times, your children are either married or, inshallah, will be married. And then the issue becomes, okay, well, will they have the time to do it? Will they have the ability to do it? So it's not a given, and it's not, an absolute or an automatic that you have to name another child as the trustee. You can name, a close friend, an uncle, an aunt, someone who is sophisticated in handling, large amounts of money in investments, etc. Because again, the responsibilities are great, right? So keep that in mind when you're naming a Henson trustee, that, the person who will be handling the Henson Trust, keep that in mind with regards to naming that individual, because again, it's a great responsibility, and you don't want to have to name someone who's just not able to do it or just can't handle it, right? Another question that has come up in the past, just from dealing with clientele, is that what if I just do not name an individual with a disability in the will? And I know it sounds perverse, but actually the thought process is not. It's actually, they've thought about it. They've given great thought to it. And the thought process is that if I do not name the person in the will with a disability, the understanding amongst the other children, if there are any other children or other relatives, is that whatever they get from that estate, they will use that amount eventually to care for their brother, their sister, their cousin, their niece, their nephew, their aunt, whoever. I've had that question asked before. It's risky doing that. If you were to just completely not have someone with a disability named in the will, there's always a chance that that brother, that sister, that aunt, that uncle may just renege on their duties as a Henson trustee, and just take everything that they could get. Remember, humans by nature are they're self-interested. I know not everybody is. Some people are altruistic, but it does happen. If there's a risk involved that person can get cut out of the will and the estate, absolutely. And then we're left with the then what? What happens then, right? But the reason why the question is asked is because it's an estate planning matter. It's also the fear that naming a person and having the Henson Trust may create complications. So there's a lot of things going in the background, right? When you're making that decision, my advice is to just have the Henson Trust, because it's there, it's a tool, it's available. It makes sure that those kind of issues are not apparent or become apparent after the fact. So that's my advice. The other parts of the will basically speak of what are the rights of an executor. Again, it basically say that the executor has the right to invest your estate however they deem fit in their best interests. It's a lot of protectionary clauses because there have been instances where executors have been sued by beneficiaries for not maximizing the value of the estate the way the beneficiary thought they ought to have. There are other clauses that basically state that if you were ever to be sued after you die, that your executor would be the person who would handle the litigation, the lawsuit. There are other things with regards to family law matters, and so there is always, I usually will put in a clause in a will that says that if any of your beneficiaries were to be married, and should they divorce after the fact, then their spouse cannot claim from their estate. There's trust clauses in there as well, apart from the Henson Trust, about ages, because I do know that some of you may have children that are under the age of 18, under the age of 20, under the age of 21, and the question comes up, well, I don't really want my child to get potentially hundreds of thousands of dollars, and they're only 18, 19, 20, they may just blow it all. So there is a trust clause in there that basically says that your beneficiary, if they don't reach a certain age, they don't get the entire amount. It's held in trust, and they're basically paid out from that for their needs. Some of my clients have staggered it, so basically they'll say 50% of the value of their inheritance will be given at the age of 21 and the other 50 at 25. There are laws that have been developed since the 1800s that basically say that if all of your beneficiaries reach the age of 21, and if there is a trust, that they can all defeat the trust. They can basically say, listen, we're all over 21. You can't tell us what to do anymore. Those are very rare, right? Very rare circumstances, but it's there, right? The law is there. All right, so that's basically a nutshell of the will. I know a lot of individuals have questions with regards to power of attorneys as well. We prepare that. Power of attorneys, so just to clarify, a power of attorney applies when an individual is alive but incapable of taking care of themselves. And so there are two power of attorneys. There's a power of attorney for property and there's a power of attorney for personal care. The power of attorney for property deals with your house, your bank accounts, your investments. The power of attorney for personal care is exactly what it sounds like. It's basically doctor decisions, whether someone's going to be put in a home, what medication to be administered, hospital visits, medical decisions, long-term care facilities, personal support workers, PSWs, like that sort of thing is personal care. Sometimes they're intertwined. Sometimes, you need the power of attorney for property to, obtain funds so that you can pay for certain things that are required for personal care. So it works hand in hand sometimes. Now, the question also has come to me many times. What if my child has a disability? Can I make a power of attorney for my child or my relative with a disability? It's a very loaded question. Actually, it's very complicated. The easy answer is that if your child or relative with a disability does not have capacity to take in information and to provide instructions clearly, then no, you cannot have a power of attorney prepared for your relative with a disability. Now, what the threshold sometimes it depends. So the threshold for personal care is a little bit lower than the threshold for property, and it's obvious, right? Property, people can be taken advantage of very easily. For personal care, it's basically taking care of the person. So the threshold basically required for personal care is that a person who has a disability has to understand that the individuals they're naming in that power of attorney is the person who cares for them, who will continue to care for them, and who has their best interests at heart. As long as they're able to understand that and communicate that, then you could potentially make a power of attorney for personal care. Communicate is important because they have to clearly communicate, and they have to clearly understand what's being asked of them and what the requirements are. Yes and no sometimes just does not do it, right? And it's usually up to the lawyer who's preparing the power of attorney to determine whether that person meets the requisite capacity. The requisite capacity for power of attorney for property is a lot higher. The person has to understand or know what assets they have, what assets they could potentially have, the value of those assets, where those assets are located, whether it be a bank or home or portfolio, whatever the case may be. Portfolio is probably not going to happen, but you never know. And they have to be able to understand that the person who is given a power of attorney for property is going to be able to manage that on their behalf, right? So that one is very difficult to meet for a lot of individuals in our community. So that's something to think about as well. Now, the question then arises that if that person with a disability cannot have a power of attorney prepared for them, what are our options? So this goes now into the Ontario Public Guardian and Trustee. There is legislation that deals with it. Basically, what would have to happen is that the next of kin or the person who has that person with a disability's interest best at heart would have to apply to the Ontario Public Guardian and Trustee to be that individual's guardian for person and property. And as hard as it sounds, it actually is a court document. It's a court proceedings, right? So you would have to apply to the courts to be in a state, a person's guardian for property and for person. And there's a file that, there's paperwork that has to be filled out. There are, a management checklist that has to be done or a management plan. And the management plan basically says, well, this is my plan for the person. This is what I plan to do for them. This is how I plan to afford for it. This is how, we're going to, handle the assets. This is how we're going to handle the payments from those assets, etc. It's very detailed, and sometimes it's very intimate. It becomes quite burdensome to prepare the checklist. And basically, the test that you have to pass with the Ontario Public Guardian Trustee is A, that you are close enough in relationship to the person that you have their interest in heart, and B, that your plan passes the sniff test, the smell test. Basically, is your plan the best for this person? And then, if all works out, then you get a court order appointing you as the guardian of that person's property and person. This has happened from time to time. Certain medical practitioners have their own personal, shouldn't say preference, but their own personal requests with regards to consent. I've had, parents of people with disabilities come to me and tell me that the doctor says they want the power of attorney to perform a certain procedure, or that the patient has to consent to treatment. And then the parent will say, well, this person can't communicate clearly. And then they'll say, well, we're not doing it unless you have a power of attorney. I've had other people that have had to fill up financial documentation for benefits or for, certain packages available, certain assistance available for people with disabilities. And, the question will be asked, well, do you have a power of attorney? No, I don't have a power of attorney. Well, then we can't help you. So, it is apparent to me that, some of this may be changing. There are a lot of lobby groups out there and a lot of people speaking to different people in government to see whether or not that can change. Because, for anyone who's had to deal with an individual with a disability, you're basically saying this is nonsensical, right? Like, obviously, if I'm the parent, I have the best interest of my child at heart. I know that this person needs a specific procedure, or needs certain funds, or needs certain care, or needs to be put into a certain, needs to have certain assistance. And asking me to provide a power of attorney for someone who clearly does not have the capacity to provide one, or someone to consent who clearly cannot consent, is nonsensical. Why would you be asking me that? But again, certain organizations, certain medical practitioners have their own, checklists, their own preferences, their own requirements, and it differs, right? I've had, one person say to me that my child met one doctor, they said, no, I'm not doing it. Another doctor, same procedure, said, yeah, I'll do it, right? So it depends, but the safest thing to do, and I've had clients do this before, is if your child cannot have, a power of attorney prepared for them because they do not have the requisite capacity, then the safest thing to do is to apply to the Ontario Public Guardian Trustee to be a court-appointed guardian, right? Power of attorney, in other words, for layman's term. Keep in mind that the default position of the government is that they are the best entity or agents to deal with individuals with disabilities, that they have the best know-how, that, that's the default position. And you have to prove to them otherwise, right? So that's basically what the checklist is. You have to prove to them that, you are the best person to take care of their estate, take care of their assets and their care. All right, so that's with regards to a power of attorney for personal care and power of attorney for property. The last thing I want to discuss with you today is a living will. And a living will is what's colloquially or what's commonly known as a DNR, do not resuscitate. That's what it's known as in the United States. In Ontario, we know it as a living will. And a living will basically puts the power, takes the decision out of your family member's hands to have extraordinary measures done to keep you alive. Now, this has come up in the media actually lately with COVID-19. with regards to hard discussions or very difficult discussions to be had with family members. And I do know that in the news, one doctor brought up the point that, family members in these difficult times, in these uncertain times, should probably have a discussion with their family members as to whether or not they even want to be put on a ventilator if required. Or absolutely, yes, I do want to be put on a ventilator if required, because a ventilator actually is considered to be an extraordinary measure to keep you alive. Do I want to be put on life support if required? Do I want to, have absolutely all measures taken to keep me alive before a decision is made to not, artificially keep me alive anymore? So that discussion should happen. It's a difficult discussion, but it's a discussion that, should, in our circumstances, probably should occur between family members. I know it's difficult to meet family members now, especially in our environment if you're not living with them. We're on Zoom, so maybe you can have a Zoom or a WhatsApp group or a video chat, a Skype conference to discuss. Do I want to be kept alive, or by a ventilator or by life supports? Now, the living will basically name an individual with whom the doctor will communicate, and a living will basically say that to my family members, I do not wish to be kept alive artificially. That if in the event I'm deemed to be terminal, then I would like to have medication administered to ease my pain. Palliative care is what it's known as, but to not keep me alive artificially and to let me die. In the absence of a living will, then the decision is left to your power of attorney for personal care. And in the absence of a power of attorney for personal care is given to the next of kin. Now, for individuals who have, no spouse with multiple children, that's difficult because then the next of kin are your children. And sometimes your children will not agree. Many times your children will not agree as to what to do if you were to, be in a situation where you're deemed to be terminal. One child may say yes and one child may say no, and then it becomes an issue. So you may want to think about this, that, I either A, want to be kept alive by any means necessary, or B, I just want to have medication administered to ease my pain, to keep me at peace and calm, and then to let me die naturally. That basically covers our, everything that, you would want to think about for your will and your power of attorney. I'll open it up for the next 12 minutes to any questions you may have. You can put them in the chat there. I'll put my email in the chat now to say that if you have any questions, I can send you a checklist again with regards to what to think of. If you have any questions, but right now, you're free to chat, and I'll put my email address out there right now. Let's see. It doesn't look like I'm able to see the questions right now. If any of you are putting it in. Let's see. All right, so I have one. Could a beneficiary be a person outside Canada? Yes, a beneficiary could be a person outside Canada. that person would have, you would have to speak to an accountant actually with regards to um, what would happen if that person were to obtain from your estate. And because basically they would have to declare the income that they receive from your estate as income, and they would have to declare it here in Canada and pay taxes on it. But yes, you could have a beneficiary outside Canada. If your mother and father both pass away, could the children go to custody of such person? Are there any federal provincial taxes on inheritance? Okay, good question. Okay, so if the mother or the father both pass away, you would have to name in the will a guardian for that child if that child is under the age of 18. That person would be the first person who would have to then apply to the courts to be the guardian of that child's person and property. So that whole OBGT thing, OBGT, Ontario Public Guardian Trustee matter that I was talking about, they would have to go through that process. And basically what they would say is that, listen, I'm the person named in the will to be the child's guardian. And so therefore this was the wish of the deceased, and I should be the person who is going to be the guardian for this child's person and property. In Ontario, there are provincial taxes on inheritance. It's called probate taxes. So basically what you're going to be looking at for probate taxes is there's online software calculators. Basically what you would do is you just Google online software probate tax calculator. Probate is spelled P-R-O-B-A-T-E. You type in the value of your estate and voila, it's there, right? Typically it's known as 1.5% of the value of your estate. So if your estate's worth $500,000, calculate 1.5% of that, and that's the probate taxes that have to be paid. The taxes are paid upon the application for estate trustee for a will. So in other words, when you apply for probate, that's when you have to present a check for that amount. I've had clients who have had to pay probate taxes out of their own account as estate trustees and then reimburse themselves after the fact because they just, the funds were not readily available from the person's estate. I have another question that in England, there is a law that if there is no will or in an estate over 300,000, no. In Canada, basically, it's the probate taxes that are paid according to the percentages that I just gave, right? Can you have more than one beneficiary? Yes, definitely. You can name as many beneficiaries as you want. Masood, you probably missed it before. With regards to Islamic wills and Islamic Sharia law inheritance, obviously sometimes there are more than one beneficiary and they will retain different percentages. So yes, you can definitely name them in the will. Is guardian of children a part of one's wills or is a separate process? You name the guardian of your children inside the will itself. So basically what you would do is you would say, when my spouse passes away, if any of my children are over the age of 18, this is the person who I will have as named as the guardian. Some people have children over the age of 18 and other children not. And so they would name the child over the age of 18 as the guardian. Sometimes it's a nephew, it's an uncle, it's an aunt, it's a brother, it's a sister, but you can definitely name your guardian within the body of the will. It's a good idea to have a different person for executor and trustee. You could, yeah, I've had that. You can name the same person, you can name different people, but you can definitely have different people. Again, when you're making a decision with regards to estate trustee, it's a different level, right? So, I mean, you can have, one person who's the estate trustee because, that's the person who knows your value and your assets intimately. Whereas the Henson trustee is someone who knows or can handle or understands disability rights and rules and programs available and different packages available. So that you can definitely name a different Henson trustee for sure. Can a guardian be a non-Canadian what info is required to identify them in a will. It's probably best not to name a guardian as a non-Canadian as a guardian, because that person is going to have a hard time going to court and proving that they are the best person to act as a guardian for a child. That person's going to have to show that they're probably most likely not going to be taking a child out of the jurisdiction, that they're going to be moving to the locality of the child. Now I'll use a family law example. Usually in a divorce case where there's custody and access issues available, if one parent is saying that I'm going to move the child to a totally different location, away from their friends, away from their school, away from their friendly and known environment, they're usually not going to succeed in that argument. Unless they can prove that the other parent is, totally incapable of taking care of that child in their current environment. The courts do not look favorably on people who want to move children out of the jurisdiction. So I would advise you to name a guardian that is close by to the child, who will keep the child as familiar in an environment that is most familiar to them, that would keep the most certainty and keep the most normalcy that they can have. What is the point of a guardian if a power of attorney is needed? Okay, so the point of a guardian, remember, a power of attorney is only applicable when a person is alive. Once that person dies, that person, their power of attorney is no longer valid. I'm trying to get to the purpose behind the question, but I'll try to answer it as best as I can. A power of attorney, remember, is a document that names another person as a person's representative to take care of themselves and their assets if they're deemed to be incapable of doing so. But the power of attorney can only be made by an individual who has the ability to make a power of attorney, to understand the requirements of a power of attorney, to understand their own assets, their own care, who can comprehend that, who can comprehend what it is to give someone else the rights and powers to take care of themselves and their assets. And if that person does not have the capacity to understand it and to communicate it, then they cannot have a power of attorney prepared for them. They cannot sign off on a power of attorney. It's not it can be challenged in court, and most likely it will be set aside. So in the absence of a power of attorney, this is when you have to apply to the courts to be a guardian of that person's estate and that person's property. Okay? What will happen if the disabled person died and all of his or her accounts, example ODSP, or the property? Okay, it's a good question. So, for all intents and purposes, for the most part, in our population anyway, and remember, there are different classes and types of people who receive ODSP. So it's not just individuals with physical and developmental disabilities. There are other disabilities that fall under the ODSP guidelines as well. But let's say for our intents and purposes, a person with a disability most likely will be unable to prepare a will because they just won't have the capacity to understand, much like a power of attorney for property, they won't have the capacity to prepare a will or have a will prepared on their behalf. And so what would happen is that person with the disabilities estate would be divided according to the Succession Law Reform Act, which I referred to at the beginning of the seminar. Okay, basically it'll be divided according to a percentage. If no parents are alive and they have brothers and sisters, then it's going to be divided equally amongst brothers and sisters. There are people with disabilities who are married, and if they are married, then their spouse gets the first $200,000 of the value of their estate, and then the remainder is divided according to percentages. Okay. Are there any more questions? Thank you, Adnan. All right, so let's see. It doesn't look like my messages are getting through to everyone. So if you have a pen and paper available, or if you're able to, write down my email address, and then you know, Dean Support Services, they can, if you contact them, they can be able to provide my email address as well. So my email address is ZA, F as in Frank, IR at rutmanlaw.com. So Rutman Law is RU, T as in Tom, M as in Mary, A, N as in Nancy, LAW.com. So it's Zafir at rutmanlaw.com. And if you have any questions, I'll send it out, I'll respond to you that way. But, other than that, please feel free to reach out to me. Please feel free to, if you need any other advice, please do so. I can definitely assist you with that, all right? And then what we could do is we can basically, have a consultation. A consultation will probably be over email anyway in our environment. I'm personally not meeting clients in the office. It's all being done over Zoom or Skype. And then, we can discuss setting up your will and your power of attorney. All right, guys? So thank you very much for attending. Again, it's the whole seminar is recorded. You're free to review it again. And then, inshallah, I hope everyone is keeping safe. I hope everyone is keeping healthy. And please, make dua for all of us that, Allah protects us and our family members from, the trials and tribulations that we're all facing now, whether it be health-wise from COVID-19 or financially. And then inshallah, Allah will protect us. We'll all be healthy. Our family members will all be healthy. And we'll all, we'll all get out of this together, inshallah.